Ms. Houston, just so that we're clear on the record, this was the show cause hearing originally set by the court regarding your failure to appear for Mr. Slater's preliminary examination. I further indicated to you that it was troublesome for the court that this got sat, and that at the time that it was sat, court is aware that you knew that you had taken employment elsewhere, and that Mr. Slater then appeared for a preliminary examination, in effect with not, I won't say without counsel, but without counsel that was ready to proceed regarding his statutory right to have that hearing. Further, that ultimately the court was also informed, at least by Mr. Slater, that he had not been communicated with by you except for the initial time, had not been communicated about your impending departure when he then appeared before the court. Since that time, I will also indicate to you that because of this, and I'm only dealing with the Slater matter, but there were other instances during the same time, one being in 15th District Court, and I believe one being downtown before the Circuit Court, where you were counsel of record and did not appear for those proceedings. I will say also specifically regarding this proceeding that on the date and time set for the preliminary examination, that this court, through my office, tried to contact you numerous different ways, and we did not receive a response. The ultimate thing in that is that Mr. Slater's preliminary examination, which I believe was ultimately waived, but he did not have his preliminary examination, and his proceeding was delayed by, I believe, approximately 2 weeks. So the court has issued the show cause to see why the court should not hold you in contempt and issue sanctions.
So, Your Honor, I did inform like the people that assigned me the case, I did inform them and I let them know what case I had outstanding. I was then contacted by the attorney that would be subbing in for me, and I gave him all of the information. I sent it to an email as soon as he contacted me. It was almost simultaneous. So,
but what day was that?
The day it was, so they contacted me, the sub attorney, they contacted me on March 8th, and I sent it on March 8th. Substitution attorney was Bernstein.
Yes.
And I sent him all of the discovery, everything that I had on Slater. And beforehand, I went to the special counsel office and I just gave them a list of everything that I had outstanding.
But counsel, that your obligations under the court rule are to still appear. I mean, because the preliminary examination said that was on the March 8th. That was a Friday. Preliminary examination was set that Tuesday for Mr. Slater. And Mr. Slater had not been informed when you were doing all of this.
And then I spoke with his mother, and I informed her, and then I gave her the new attorney's information with Mr. Slater's mother.
why would on February 29th, you have set this for preliminary examination when you knew that you would not be counsel, that you had accepted other employment?
I thought that another counsel would sub in for me in time. Because like I said, I informed special counsel who assigns this, I informed them, so I thought that another.
On what date did you inform them?
This was February 22nd, I believe. February 22nd, I believe.
Then why do I not receive a motion to withdraw until March 11th?
I don't know, Your Honor.
Well, you're the one, counsel, you can't just say I don't know, because you're the one responsible to withdraw from the case. Regardless of the fact that the MAC office is the one that gives your name, it is your obligation. It's not their obligation. You would agree with that. I mean, you're the attorney of record.
Understandable.
But if you knew on the 22nd of February that you were going to be withdrawing from cases, I don't, on this matter, I don't get anything until March.
My apologies. I didn't know. Like, they said they did all the motions to withdraw for me, so I thought they would have got it sooner. I did inform them February 22nd, and I thought that substitution counsel would be in before then.
Ms. Hughes, if that's true, then why on February 29th, this would have been a week after, do you appear and set the case for preliminary examination?
Because I thought.
And not inform the court, not inform the defendant, not inform anybody that you won't be counsel of record?